Even if you don't live in Colorado, this may affect you. If the Colorado law, House Bill 1224, is not stopped, it could lead to a dangerous precedent. You could see similar laws in other states or even nationwide. This is the case of 54 Sheriffs et al. Versus Hickenlooper.
Today we'd like to have the plaintiffs in this case, the 54 sheriffs and the other peaceable good citizens and organizations of Colorado who are bringing the civil rights lawsuit, explain why they're doing so. The suit also raises claims under the Americans with Disabilities Act. So now,
hi, my name is Dylan Harrell, and I'm a plaintiff in the case being brought today. I'm a Colorado resident, born and raised, who also happens to have a disability, which makes it more difficult for me to defend myself and my family, which include 2 small children. As an outdoorsman, I also often request the assistance in the safe handling of my firearms anytime I'm transferring from my wheelchair to an ATV or another vehicle. I have firearms for the purpose of defending my family that use magazines that are now made illegal by House Bill 1224. I also have firearms for sporting uses that use magazines that are made illegal by House Bill 1224. This makes it against the law for me to even seek assistance now in the handling of my firearms anytime I'm transferring into or out of my wheelchair. I'm taking part in this case today because House Bill 1224 violates my Second Amendment rights and also the rights of all Coloradans, including and especially other Coloradans with disabilities such as my own. Thank you.
This is a fundamental right, and a right that House Bills 1224 and 1229 violate. Women for Concealed Carry is a nonprofit organization committed to preserving innocent life. We advocate for a woman's ability to determine how to defend herself and her family. We are committed to working with lawmakers to ensure all laws allow women meaningful defense options when confronted with evil. The ease with which the governor and the state legislature dismissed our safety concerns is troubling. We believe House Bills 1224 and 1229 unconstitutionally restrict a woman's right to self-defense. So today we ask the court to declare these bills void. For the sake of our lives and the lives of our young children, we ask the court to issue injunctions against the enforcement of these dangerous bills. Briefly, I will describe why House Bill 1224 is so dangerous for women in Colorado. According to the Colorado Bureau of Investigation, forcible rapes are becoming more and more common in the state. Last year, there were 2,236 forcible rapes reported in Colorado. And this number does not include those that went unreported, as most do. As women, we do not carry concealed handguns because we think we will be attacked or raped by a stranger. We carry because we already have been or don't want to be. House Bill 1224 will make it much more difficult for a woman to defend herself and her family. Governor Hickenlooper and the bill sponsor say House Bill 1224 bans all magazines with removable floor plates or end caps. And the majority of handgun magazines have removable floor plates. Most handguns will not work without a magazine, so this bill bans more than magazines. It effectively bans the handguns to which they attach. Banning the ordinary magazines women use every day for lawful self-defense makes our handguns useless. And it makes us more vulnerable to violent crime.
Many of our farmers and ranchers need access to firearms to protect their livestock from predators, especially during the springtime when most young are born. They also need access to firearms to protect themselves and their families. Because in rural areas, law enforcement is spread very thin, and very seldom is there an officer just around the corner. Most farms and ranches in Colorado are owned and operated by families, which may include several generations: aunts, uncles, cousins, in-laws, or stepchildren. Many of these family operations are incorporated as LLCs or family partnerships or other partnerships that may include non-family members. Requiring background checks for transfers between these partners creates an unfair burden to farmers and ranchers, as there are not very many FFLs available to perform these background checks in rural areas. In addition, many of the people in rural Colorado engage in hunting and recreational shooting. These activities take place certainly among family members, but not only family members. They include neighbors and friends. This bill would limit the ability of sportsmen to loan their weapons to their hunting partners. It means a farmer cannot loan a firearm to a friend, without a background check. It makes youth hunting and sporting activities very difficult to encourage. It creates a patchwork of confusion for thousands of hunters who enjoy recreation on the open vistas that are provided in Colorado by farmers and ranchers. The law banning magazines that hold more than 15 rounds unknowingly, and I believe unintentionally, criminalizes an otherwise law-abiding citizen. As has already been stated, nearly every magazine has been designed to, quote, be readily converted, and limits the ability of a farmer or a rancher to protect himself, his family, and or his livestock. A ban on the number of rounds that a magazine can hold could in fact mean the difference between life and death. If a farmer or rancher needs to take the time to reload his weapon when a predator such as a bear is advancing on himself or his livestock, he could potentially take too long and lose his life or those of his livestock. The requirements of these laws are unreasonable.
We are here today because of the reckless manipulation of our lawmaking process. When transparency and public input are ignored, bad laws are enacted. These laws have no factual basis or supporting empirical evidence. When a law broadly targets law-abiding citizens at a greater proportion than criminals, it's a bad law. When the laws violate citizens' freedoms and rights, it's a bad law. When the governor admits it's unenforceable, it's a bad law. Let me share an example of the overreaching abuse of these laws and how law-abiding citizens will be criminalized. I have a very good friend of mine that is a member of our military. He has been deployed numerous times to fight terrorism abroad and restore the freedoms and rights to citizens in foreign countries. We were sitting around the table one day several weeks ago talking about his upcoming deployment and these new bills that were at the time being signed by the governor. His fiance asked me, "Sheriff, why do you have issue with this background law?" And I turned to my friend Troy and I said, "You're going to be deployed. Are you going to leave a firearm for your fiance?" He immediately replied, "Absolutely." Almost simultaneously, she said, "He better." Now keep in mind, it's a fiance. They're not married, but they do share a residence. He was shocked, as was she, to find out that if he left a firearm for her while he is off serving our country, they would be committing a crime. I then asked him if his magazine contained more than 15 rounds, at which he said it did. I asked him, does it have a removable base plate, which he said it did. They were not only shocked, but even more angered to find out that not only would they violate the background law, they would also violate the magazine ban law. Are these the people that we should be targeting and criminalizing? The answer is no. Today represents a line in the sand. Today, 54 sheriffs stand side by side and defend the rights and freedoms of our citizens of this state. The filing of this lawsuit is our only option. We did not ask for this, we did not want this, but we will not stand by silently while good citizens are deprived of their rights and criminalized. We each took an oath. The line in the sand has been drawn, and we will stand united. Thank
We
you.
were reassured by the proponents of these laws that not to worry, they had good intent. The citizens were told these have noble intent. When the errors in their drafting were pointed out, we were encouraged to simply look past that noble intent. We as sheriffs know the intent of the law is not what's going to be applied on the citizens. It's the word of the law. These laws are absolutely flawed. As a sheriff whose community suffered tremendous wildfires over the last year, where tens of thousands of acres of my county burned, hundreds of homes were destroyed, and thousands of residents were evacuated at sometimes only moments' notice. Many of my citizens' rural areas packed up what few belongings they could in their vehicles, and they fled. Many of those took with them their treasured firearms. The way these laws were authored, the way they were signed by the governor, when they take those firearms and temporarily transfer them, take them to a friend's house for safekeeping, they will become criminals under Colorado law. When they take a magazine that's over 15 rounds or capable of holding and being converted to more than 15 rounds, they and the person who accepted it become criminals. Sheriffs, we could not stand idly by when we saw such intrusions on the rights, the sacred rights of the citizens of our county. To the silenced majority, again, the silenced majority of local police officers, Colorado state troopers, and yes, many federal agents who have come forward have reached out to myself and my fellow sheriffs, seen in this events, put their hand out and said, thank you. Thank you for speaking up for the things that we believe, but we are not allowed to come forward and say. So on behalf of the citizens, on behalf of those involved in this lawsuit, on behalf of the peace officers around this state who've sworn those sacred oaths, we will step forward, we will stand up, and we will bring justice back to the state of Colorado.
The laws, for the reasons described, and for many others, violate the Second Amendment of the Constitution of the United States. Portions of the laws, such as continuous possession, designed to be readily converted, are unconstitutionally vague and also violate the Due Process Clause of the 14th Amendment of the Constitution of the United States. And as applied to disabled citizens who are entitled to reasonable accommodations under Title II of the Americans with Disabilities Act, the laws also violate the Americans with Disabilities Act. There's a problem that as you've heard, lots of innocent transfers, temporary transfers of firearms, like leaving your guns with your neighbors when your house is burning down, are crimes under this law, punishable by 18 months in jail. In addition, we also point out that the background check system is in practice going to be very difficult for citizens to comply with, because to get this permission for a temporary transfer or a sale of firearms between friends, you have to go to a federal firearms licensee, a licensed firearms dealer. The House Bill 1229 says the maximum fee that the dealer can charge for that is $10. And based on our research so far, there will be very few, if any, firearms dealers who are willing to undertake this time-consuming process of the paperwork, the legal risks they face when filling out the paperwork, the time it takes, the hours or days for Colorado's so-called instant background check, so that in practice it may be almost impossible for citizens who want to go through the background check process for a private transfer to be able to do so. Sure. The 14th Amendment says that no state shall deprive a person of life, liberty, or property without due process of law. As the courts have, I think, correctly interpreted that, it means that citizens have a right to know in advance what the laws are so they can comply with them, and the laws have to be things that they actually can comply with. So you couldn't enact a law that says everybody must be 7 feet tall. You likewise can't enact a law that says everybody must, when leaving your gun at the neighbor's house after you're fleeing your burning home, you've got to go to a firearms dealer and have the background check done, when in fact there's no firearms dealers in your area, who will do that background check for you for the measly fee of $10. And likewise, people are entitled to clarity in the law. The language about designed to be readily converted either means what it literally says and what the sponsor and what the governor said it means, which is a massive ban on magazines, plainly violating the Second Amendment, or if it means something less or different than that, then nobody can really tell what it means, and it's unconstitutionally vague. Likewise, the requirement that grandfathered magazines be under continuous possession either means what it seems to literally say, which is Dylan can't hand a rifle, which has a magazine with a removable end cap, to someone for 10 minutes while Dylan gets in and out of a vehicle, or it means something different from that and and nobody knows what that is, and it's unconstitutionally vague. For the transfer of guns, there is a 72-hour exemption. For magazines, no exemptions at all. Grandfathered magazines must be under continuous possession, period. That's the end of it. The governor, when he knowingly signed these flawed bills, said that he would work with for the creation of guidance for the enforcement of these laws, and which, as Sheriff Cook said, that's a euphemistic way of saying actually what these bills really say is clearly unreasonable, so I'm going to oversee the creation of guidance which will tell law enforcement, oh, don't enforce the law as it's actually written in certain situations. But all that is it's called guidance for a reason. It is not legally binding. Nothing the governor's office or the attorney general's office or the Colorado Department of Public Safety produces as a guidance document can order the Denver Police Department or any other police department or any local sheriff's department or any local law enforcement anywhere in the state. That guidance is not binding. It is merely a suggestion, and it can be changed anytime by any future government officials. So,
well, it's not a matter of whether, I'll speak for myself, it's not a matter of whether I choose to enforce it or not. It's unenforceable, which is one of our key elements. The scenario I gave with the soldier that is a friend of mine, I doubt I'm going to go down the street each time I know he's deployed and ask him to present me a background check, because I have more important things to do, and he's not a threat to society. He's a threat to terrorists, not to citizens in our community. So the question is kind of a circular question that there is no answer. I can't enforce what is unenforceable, which is part of our lawsuit.
I am Andrew Hagle, and I brought you this message. Please join me on social media to continue the conversation. I'm on the Experience Project as Snickle Fluffy. On Twitter is Truckin' Hubby. On Patriot Action, Vimeo, YouTube, and Facebook under my own name. Thank you for watching, and God bless. And please remember to stand up for your Second Amendment rights. As our founding fathers have said, they are core to our freedom and must be protected.